File 24-6937FH. Counsel, you want to state your appearances, please?
Mr. Goodrich, Sheboygan County Prosecutor.
Gotcha. Attorney Surin Panainte, P number 85326 for defendant, Mr. Robert Bradshaw.
All right, and I scheduled this for a status conference. In this case, I had entered a ruling denying a defense objection to certain evidence that the prosecutor was intending to present at trial. The defense moved for a stay to facilitate interlocutory appeal, and I granted that motion and stayed the case pending appeal. However, on review of, I periodically sort of review our cases that are up on appeal so that we know whether we need to take action on remand. And I saw that an appeal had not been filed in this matter. So I guess, Mr. Panainte, the ball's in your court. I guess I wanted to find out if your intentions had changed. What's the story?
They have, Your Honor. Upon discussion with Mr. Bradshaw, we have decided to not pursue the appeal voluntarily. We would proceed with the court's ruling as it has been made in regards to that evidence. And we would ask the matter be set for trial. I have, in the meantime, communicated with prosecuting attorney Goodrich, who has provided an updated offer in this case, which we would likely place on the record and note that the defendant would reject that and would request that he have his jury trial instead.
Okay. So what was the offer that was made?
The offer, Your Honor, if my screen will turn back on, it has, is that in exchange for the defendant's plea to guilty to one count of DV third, there's a sentence agreement of a 1-year county jail cap, alcohol tether upon release for a time determined by an MDOC agent or the court, and the no contact order with the victim shall continue during probation. I would note, and the court may sign that form if it's in the file with my permission, that Mr. Bradshaw is rejecting that.
Okay, I don't require a rejected plea offer to necessarily be written in the file. So just for record purposes then, Mr. Bradshaw, you understand you have the absolute constitutional right to a jury trial, and nobody's intention here today is to try to strong arm you or persuade you to do anything other than that. We just want the record to be clear that you have been tendered an offer for to resolve the case. Do you believe you've had sufficient time to review that offer with your client or with your lawyer? And so do you believe you've had sufficient time to review that and review your options with your attorney?
Yes.
All right, and his job is to give you some advice, but the decision whether to take a case to trial or not is yours and yours alone. And so you are deciding you want to exercise your right to a jury trial?
Yes, I do.
Okay, that's fine. And previously we had scheduled this for a 1-day trial. Does it remain a 1-day trial? Ms. Goodrich?
I believe we could probably do it in a day. I don't recall how many.
There is an
witnesses
edit.
defense had.
There is the added witness from the court's earlier motion, so I don't know if the added witness would require a second day. That's the question.
I guess we should do 2 to make sure.
Yes.
Well, I was. Let me see. All right, so was discussing with counsel scheduling issues, and it looks like we could set this for jury trial on Thursday, October 23rd. I believe witness and exhibit lists have already been exchanged. Is there any need to amend based on the court's prior rulings, or?
No, I don't believe so, Your Honor.
Okay. All right, so we'll set for 1-day trial. 3rd. Witness and exhibit lists have already been exchanged. There will be jury instructions and verdict form not later than 7 days prior. This case is it seems to me that we don't necessarily need another docket call then. We could, okay, so I won't schedule it for further docket call. All right, anything further from the defense?
Yes, Your Honor. With the court's permission, I'd like to make the motion for bond.
Okay, go ahead.
Your Honor, if I may remain seated for that motion.
That's fine.
Thank you. Your Honor, Mr. Bradshaw has some 300 days credit. Admittedly, part of the delay is pursuing that appeal. But ultimately, Mr. Bradshaw's guidelines, at least from my first scoring, were straddled. He has already served 300. I mean, he's close to almost a year now. By the trial date, he will have served a year's time. But taking that into consideration, considering both the speedy trial rule as well as some matters I have been informed of, it is my understanding that Mr. Bradshaw, while he's been lodged in Cheboygan County Jail, has been assaulted and is the victim in a case. It is also my understanding that that assault may have been directed by one of the witnesses named in this complaint, or at least related to her. It is also the fact that Mr. Bradshaw has substantial medical matters that require treatment. Unfortunately, he'll have to find his own transportation to any treatment center or any hospital that he need. He would also indicate to the court that the food that's being provided to him is not of the quality that he would need for his medical conditions. At the preliminary examination in this case, it was discussed with the complaining party, Ms. Juanita Engelbrand, how Mr. Bradshaw needs care. I don't think it's in dispute that he has medical necessities. He would have to find his own transportation to court. He would report to probation as directed, and I understand that the court's concerned about sobriety while the case is pending. If that is the case, I would ask that the court place Mr. Bradshaw on a sober link or a scram monitoring device. The one issue that he has, Your Honor, while he's been lodged this whole time, any funds that he does have access to pay for that are not available to him immediately. We'd have to go to the bank and get that. That's correct. Simply put, Your Honor, Mr. Bradshaw would ask that he be released.
Okay, thank you. Ms. Goodrich, your position?
Your Honor, Mr. Bradshaw has previously motioned the court to amend bond. I don't believe there's been any change of conditions other than his request for appeal. And as we waited for that to play out, we are now set for trial. I would ask that the court deny.
I think, if I'm remembering right, bond had been revoked pre-bind over. Is that right? Okay. And then some of these very concerns were addressed back in February on a motion to reinstate bond, which I did not grant. At some points, Mr. Bradshaw's phone privileges were even restricted in the jail for continuing to violate conditions even after he was jailed. We had this case set for trial on June 2nd. And now we're 3 months, or we're 2 months later, because then back in May, the defense wanted me to put the case on hold so they could appeal, which is fine, that's their right. But that was 3 months ago. So, I mean, the defendant says, put everything on hold, and now 3 months later says, gee, I've been in jail for a long time, let me back out. I mean, that delay was caused by the defense. I mean, I just don't see that that's a reason for me to let you back out, Mr. Bradshaw. So that motion is denied. Mr. Bradshaw will continue to be held without bail. And we have your trial scheduled as soon as I can schedule it. I had it scheduled back in June. You wanted it postponed, so it's postponed. That doesn't mean you get out of jail. So you'll remain in jail, and I'll see you next for your trial on October 23rd.
Your Honor, just for the record, I would also like it noted that there was in fact a state emergency with the ice storm at our original trial date.
Oh, okay. Well,
That was the original delay.
And
all right. Well, that's fine.
And I didn't know that I
The
was
case has
allowed
been
to call
stayed
it.
for 3 months and no appeal was taken. That's not my fault. That's totally, so the last 3 months delay is 110% the defense. So the delay.
At the time when I called her, I didn't know.
We're done, Mr. Bradshaw. See you in
Say
October.
nothing, Rob.
You'll go with the bailiff right now. You can talk to your lawyer later. We've got other court to do. You're going to go right now with the bailiff.
Thank you, Rob.
All right, thank you.
Thank you.
All right, next. We've got sentencing and people v. Joe Skribic, file 25-6980, 6981, and 6982. Counsel, you want to state your appearances?
Mr. Goodrich, Sheboygan County Prosecutor.
Appointed for Mr. Strivick, Your Honor.
Good afternoon. Let's see, we're here for sentencing in 6980, possession of meth, habitual fourth, guidelines 10 to 46, 6981, delivery of meth, habitual fourth, guidelines, the one was possession. 6981 and 6982 each have a single count of delivery of methamphetamine. Both of them scored initially at 72 to 240 months. Have you had a chance to review the report and recommendations with your client?
Yes, Your Honor, we have no factual additions or corrections and no challenges to the scoring of the guidelines.
Okay, any additions, corrections, or scoring challenges from the people?
No, Your Honor.
Anything you'd like to say on behalf of your client?
Your Honor, Mr. Strivick is very much aware of the opportunity that lays in front of him right now with recovery court. He is determined to avail himself of that opportunity and to not waste it. So far, so good. He's been doing very well from what I understand. And he knows that if he steps out of line, he's going to go to prison. That's all the motivation anyone should need to get their life in order. And I believe he's going to do that. We would ask that you honor the agreement and allow him to continue in the recovery court program because I think that will change his life.
Thank you, Mr. Ford. Mr. Stribic, you don't have to say anything today. It's not required to, but you're allowed to make any statement you wish. Is there anything you want to tell me?
I just want to say that I appreciate you guys giving me a chance to do recovery court. Really messed up this time and I didn't think I even had a chance. It was the most trouble I've ever been in my life, you know, and I take it serious.
Thank you. Ms. Goodrich, any recommendations from the people?
Your Honor, I continue to be in agreement with recovery courts. I believe that Mr. Strivick was sentenced yesterday in Emmett County.
It was a plea last week in the sentencing.
Oh, okay. I believe that the plan is for that case to also be sentenced into recovery court.
All right, well, Mr. Stribic, you're 44 years old. You have 8 prior felonies before this case. And this case involves, more than one delivery of methamphetamine, 20-year Class B. We've got the Emmett County case. It sounds like they're going to let you participate in our program as well. I'm glad to hear that you're, taking this seriously, and I genuinely hope that this case is the one that changes everything for you. That's entirely up to you. And you've got a long way to go. It's a 2-year program. If you run into problems, be honest with us. We'll try to help you solve those problems. Because you need to know, these guidelines are high guidelines. When you have 8 prior felonies and the level of your involvement in the criminal justice system for years and years, you are not looking at a low end of the guideline sentence.
I know.
Joe, you're staring at 10 years or more.
I know.
So you got to do whatever you need to dig deep
Okay.
and make whatever changes you got to make, whether it's people, places, things, habits, thoughts, whatever it is. But if you've only done 6 days jail, we're going to give you this treatment court option. So with your record with felonies and with delivering methamphetamine on multiple cases in 2 different counties, you're going to do 6 days in jail.
Yeah.
That's like absurdly lenient, because we're going to see whether you can put this behind you.
I'm not trying my hardest. I think I'm going to.
Okay.
I am taking it really serious.
Well, you need to know that also, a lot of people don't make it. They say the same things that you're saying,
I know.
but there are people that do. So there's no reason for you not to graduate the program, Chuck. People do recover. Happens every day. So you're not different than other people who've struggled with addiction. Your problems are not bigger than theirs. I promise you, I've seen people with bigger problems than you. So you can do it. The only question is, are you going to do it?
Thank you.
One analogy I like to use a lot is do you like sports at all?
Yeah, football.
Yeah, football is the only one I really love. Every football team wants to win.
Yeah.
But who actually wins is the football team that wants to practice, that wants to show up and sweat, that wants to put in the hard work. So just wanting to recover is not going to do it for you. You're going to have to want to get your butt out of bed and go to an AA meeting when you don't want to. You're going to have to want to break a relationship that maybe you need to. You're going to have to want to do the things that hurt. That, just wanting to win is not going to translate to a win. All right, well, that's the best lecture I got for you.
Yeah. Good.
Mr. Stribick, I find under the law that Mr. Stribick is or was dependent on or abusing drugs or alcohol and is an appropriate candidate for participation in a treatment court program, that he understands the consequences of entering in that program and has agreed to comply with its terms. I find that Mr. Stribick is not a violent offender. Also, that he's not an unwarranted or substantial risk to the safety of the public or any individual based on the information available to me in a pre-screening and a pre-sentence report. So therefore, I am going to sentence you to our recovery court program as recommended. So in file 6980, possession methamphetamine, 10 to 46 months guidelines range. You're placed on probation for 30 months, subject to the terms and conditions listed in the pre-sentence report. Chief among them is that you comply with the recovery court program. There's also $130 crime victims assessment, $68 in state cost. And that is a downward departure from the advisory guidelines of 10 to 46 months. The reasons for the departure is his suitability and acceptance into a treatment court program. In file 6891, on the charge of delivery of methamphetamine, I'm going to place you on probation for 30 months, subject to the terms and conditions listed in the pre-sentence report on pages 4 and 5, 4 through 6. Chief among those conditions are the Cheboygan County Recovery Court Program. In that file, there's restitution of $60, crime victims assessment of $130, court costs of $350, state cost of $68, and a treatment court participation fee of $600. That is a downward departure from the advisory guidelines range of 72 to 240. I find that there's a reasonable grounds for a downward departure based on his suitability and acceptance into a treatment court program. In file 6982, we're going to place you on probation for 30 months, subject to the terms and conditions listed on pages 6 and 7 of the pre-sentence report. Chief among them are that you complete the Cheboygan County Recovery Court Program. In that file, there's a crime victims assessment of $130 and state cost of $68. That is a substantial downward departure from the advisory guidelines of 72 to 240 months. I find a reasonable basis for such a departure in Mr. Stribick's suitability and acceptance into a treatment court program. All those sentences would run concurrent with each other. Mr. Stribick, if you wanted to appeal, you'd have to file an application. If you wanted a lawyer, you'd have to make that request within 6 months. We're going to hand you appeal paperwork in all 3 files, 2 copies in each of the 3 files. 1 copy, we want you to just initial it so we have a record that we gave it to you. The other one is for you to fill out if you want to take an appeal. You have any questions for me?
No.
Okay, good luck and we'll see you tomorrow.
Thank you. Thank you, Your Honor.
Thank you, that's all I